Welcome to SHERLOC Exposes. My name is R.C. Williams, co-founder and co-CEO of SHERLOC. We specialize in in-depth market research, competitive intelligence, and the design of advanced technologies. SHERLOC Exposes is an ongoing series where we look to root out corruption, collusion, and other things at all levels, and to make sure those who are either misguided or misappropriated get a fair shake, and their story sees the light of day. In this edition of SHERLOC Exposes, we'll cover the Bellwether case of the United States versus Randall Crater, held in the U.S. District Court, District of Massachusetts. This Bellwether case pits the CFTC, the DOJ, the FBI, and the federal courts against technologist Randall Crater. In this series, we'll discuss the case and my big coin, exactly what happened, and the depths that the U.S. government system will go to in order to get their way, for power and for financial gain. U.S. Government Exposed, Part 1, Why, Who, and How, Setting the Stage for Weaponization. If you need any information or documents from this series, you can find them at SHERLOC, that's SHERLOC.substack.com. SHERLOC.substack.com. If you'd like to see any of our press releases or any other information, you'll find it there. Quote, I didn't know that you could be charged and convicted on something for a company that you don't own or control. Anonymous. That was the opening line of our initial announcement. Sounds crazy, right? When it comes to the federal government of the United States, their alphabet agencies, money, and power, nothing is too crazy. Enter Randall Crater. As it turns out, Mr. Crater appears to have a strong sense of justice. He also committed the cardinal sin in dealing with the government. He fought, proclaimed himself innocent, and called for due process. That call would lead to the strong arm of the law showing itself, along with death threats against Crater and his family, public ridicule, stalking, and humiliation. In this expose, you will find links to documents that show motions, depositions, and sworn testimony provided to us by whistleblowers that documents the gross negligence, willful ignorance, withholding of evidence, and conspiracy between multiple government agencies: the Securities and Exchange Commission, or the SEC, the Department of Justice, or the DOJ, and the Commodity Futures Trading Commission, or the CFTC. All supported by the federal court system, and all working together to weaponize the legal system. The reasons? Power and money. The U.S. versus Crater case is a bellwether, meaning that it will set precedent for all cases that come after it. A win by the CFTC would give them, in essence, complete control and oversight of cryptocurrency. That's a lot of power, isn't it? Well, the CFTC sure thinks so. How much, you may ask? Enough for the agency to testify to the Banking, House, and Urban Affairs Committee of Congress to utilize the case of U.S. versus Crater to make their case for hundreds of millions of dollars in funding, which they received. Yes, the CFTC leveraged a case which was built on hearsay and, in fact, should have been thrown out to obtain taxpayer, aka your, funds. We'll break down the contentions made by the CFTC, which led to what is, in essence, a show trial for political and financial gain. We'll also show how one motion for sanctions that was not allowed to see the light of day would have completely exposed the CFTC's methods when someone stands up to fight them. Squeezing targets through crippling asset freezes, random closing of bank accounts, and supposed quote-unquote victims of fraud that either do not exist or were never interviewed or called to testify. Yes, you heard that correctly. Exonerating evidence in a bellwether case was not allowed to see the light of day. Of the evidence that SHERLOC has reviewed and will share, perhaps the most disturbing of all may be the deposition of the CFTC's star witness, expert Patricia Gomersall. As you will read when you look at the excerpts from her deposition, and you will hear in this audio recording, Gomersall performed little to no due diligence while making statements to the contrary. made unsubstantiated claims and admitted that she had no basis to believe that the MyBitcoin currency was not backed by gold, or that there were actually 28 fraud victims. The cover-up ends, and the process for justice begins now. Meet the players. The visual diagram of Meet the Players is available at SHERLOC, that's SHERLOC.substack.com. While the trial in question featured only one defendant, Crater, the ecosystem of players is extensive. John Roche, owner and CEO of MyBitcoin Inc., heir to the Disney fortune and longtime friend of Harmony International owner and CEO Bill Donahue. Mr. Roche not only designed and controlled the MyBitcoin website and social media, he advised the government that he indeed owned MyBitcoin. His statements to FINRA, the FBI, and the Postal Inspector tell a conflicting story. Bill Donahue, owner and CEO of Harmony International and longtime friend of MyBitcoin owner and CEO John Roche. In tandem with Roche, Donahue handled the logistics for gold backing for MyBitcoin. He also forged documentation on the gold that was supposed to back MyBitcoin and defrauded Randall Crater in the process. Randall Crater, owner and founder of Grayshore Technologies. The government alleges that Crater was the founder and owner of MyBitcoin, yet provided no evidence to actually support the claim. Crater licensed technology and provided technical assistance to Roche and MyBitcoin and was a minority shareholder in the company. Mr. Crater was also defrauded by Bill Donahue after putting up money for gold. Adam Tracy, lawyer. Tracy reported directly to Roche. Michael Kruger, associate. Kruger advised the FBI on multiple occasions that Roche ran and controlled MyBitcoin and offered to provide extensive documentary evidence. Mark Gillespie, associate. Gillespie also advised the FBI that Roche ran and controlled MyBitcoin. Background. MyBitcoin, or MBC for short, was established in 2013 by John Roche. Its business model, like most cryptocurrency businesses, was to utilize blockchain technology in numerous business applications, like gaming and the equally growing cannabis industry. The selection to name MyBitcoin, which was similar to the largest and most well-known cryptocurrency in the world, Bitcoin, was probably a mistake in hindsight, but nonetheless, all efforts to grow a fully functional business and currency was the goal. In 2014, Roche, as owner and CEO of MyBitcoin, retained Randall Crater to build the technology to support the business model. Also originated and added to MyBitcoin was MyBitcoin Pay, which would add a layer of utilizations and revenue, such as ATM machines and credit cards backed by the new currency. In its Twitter account on January 21, 2014, MBC stated that a price of $23.17 was transacted. MyBitcoin was being heavily marketed and promoted, and peer-to-peer transactions were being transacted and disclosed by John Roche on its own website and through social media such as Twitter. According to Roche, like Bitcoin, MyBitcoin was going to limit the number of quote-unquote coins to 30 million. Users were being urged to create accounts and quote-unquote wallets to hold their MyBitcoin. In one of the biggest announcements made, on March 6, 2014, NBC announced that they had created a partnership with a company who would back all MyBitcoins with gold. This was an incredible declaration. NBC was now stating that MBC was being transacted at $52.88. Additionally, another announcement was made that owners could obtain a Visa MasterCard backed by MyBitcoin and used in any store that accepted MyBitcoin. They also announced that an IPO, initial public offering, was imminent, and they wanted to become the #1 cryptocurrency in the world. Shortly thereafter, MyBitcoin was disclosing that transactions were being made at over $102. In November, MyBitcoin claimed that their agreement with a credit card company was finalized, and MyBitcoin was being transacted at $121.38. However, in mid-year 2014, while MyBitcoin's attorney Adam Tracy was trying to conduct a reverse merger by acquiring a dormant company, FINRA started an investigation into MyBitcoin, inquiring if they were selling shares not registered or exempted from registration. By year's end, FINRA had written a letter to the SEC stating that their investigation was completed and that they were not going to move forward with any further proceedings. Subsequently, the SEC did not pursue any further investigations. What FINRA did do, and is the normal course of business in Washington, is pass along the case to the CFTC for investigation as well. It is not usually clear how certain cases get, quote, moved to the top of the pile, unquote, but interagency, quote, recommendation, end quote, is a certain way it will rise to the top. Roche and MyBitcoin continued to promote MyBitcoin and MyBitcoin Pay. Crater, through his licensing and consulting agreement, continued to build the infrastructure. The IPO, initial public offering, never took place as the company that Tracy was trying to reverse merger with, Shot Spirits, was not allowed by the Depository Trust and Clearing Corporation, DTCC, to sell its shares again. In 2017, the CFTC disposed a MyBitcoin owner, both in coin and an investor in the company named John Lynch. Lynch was a notable real estate attorney in Massachusetts for over 40 years and was a former assistant district attorney in Boston for Suffolk County. He then had an unsuccessful attempt at running for state senate, but was able to land a job for the city of Boston defending various state agencies. In Lynch's deposition, he clearly states that he received coins for not only him, but for his law partners and family. On January 16, 2018, the CFTC filed a civil complaint in the Federal Court of Massachusetts, 18 CV-177. It named Randall Crater and MyBitcoin as defendants, as well as an NBC salesman and support person named Mark Gillespie. It also named Crater's mother, wife, and sister as relief defendants. It also named Grayshore entities controlled by Crater as marketing and technology companies. Most notably, the suit did not name the actual CEO of MyBitcoin, John Roche. The suit basically stated that MyBitcoin and MyBitcoin Pay were a, quote, Ponzi scheme, unquote, crafted by Crater, and all representations made on social media were false, including that MyBitcoin was backed by gold, and the claim that it had entered into an agreement with Visa MasterCard was false. It stated that no, quote, wallets, unquote, were ever created in the MBC exchange through its website, and it did not trade on any other exchange. That proceeds collected from these fraudulent sales were then sent via wire and check to bank accounts controlled by Crater, his sister, mother, and wife. Gillespie is claimed to have controlled the Facebook page of MyBitcoin and also made false claims. It does not state who controlled the Twitter account or who authorized the press releases. Warning, legalese ahead. According to the federal rules of civil procedure, plaintiff's initial complaint and allegations are to be construed as quote-unquote true by the courts until such a time as they are asked to back their claims. First and foremost, though, was the issue of does the specific court have jurisdiction to even hear the case? On May 4, 2018, Crater and the relief defendants filed a motion under Rule 12b that the court did not have jurisdiction to hear the case because MyBitcoin was not a quote-unquote commodity, as defined in the Commodity Exchange Act. The motion was written by Laura Greenberg Chow and Catherine Copper, who had over 20 years' experience in the derivatives markets and had actually worked for the CFTC as a senior trial attorney. This was a crucial issue, though, because granting jurisdiction to the CFTC under the current CEA before Congress could decide who would grant authority, not through elected officials' legislation. On September 26, 2018, Judge Zobel ruled in a decision laid out over 11 pages that my Bitcoin was a commodity. She referenced a precedent case of CFTC versus McDonald, 287 F Supplement D 213-228, EDNY 2018, which granted jurisdiction to the CFTC, but that case involved Bitcoin, which had already been granted regulatory permission to trade on a futures exchange. That sole decision opened the door for the CFTC to now submit dozens of cases over the past year. Just before Judge Zobel's decision, the CFTC filed an amended complaint with the court and now named my Bitcoin owner and CEO John Roche, as well as a man named Michael Kruger. My Bitcoin and My Bitcoin Pay are now defunct entities. All individuals named defendants, Roche, Gillespie, and Kruger, have defaulted. Only now Crater was left as an individual defendant. Noticeably, the quote-unquote Ponzi scheme allegation against Randall Crater was omitted from the amended complaint. That allegation earlier led to a government press release and Pacer postings, not only stating that Crater organized a Ponzi scheme, but improperly publishing contents of the FINRA investigation. Most notably among these contents was a credit reporting agency document asserting that Crater had an extensive criminal record in several states. That document was not only false, but plainly listed on its face were the words, quote-unquote, not for public dissemination. The government retracted the quote-unquote Ponzi scheme, knowing that it had no evidence to support the allegation, but posted false and damaging information on Crater, thereby causing the holders of My Bitcoin to erroneously believe that Crater possessed a significant criminal record. Ironically, a day prior to Zobel's decision, a lead investigator for the CFTC named Patricia Gomersall was deposed in the civil case. She clearly stated that FINRA had recommended the case to the CFTC through her supervisor, Paul Hayek. She was the lead investigator with 31 years of experience and had submitted a declaration to the court under penalty of perjury, but in her deposition could only name John Lynch and another quote-unquote victim, Peter Bell, as one of 28 victims stated in the complaint. In fact, in reading the deposition, which is directly linked at sherloc.substack.com, it was frightening to see how little investigation was actually done before ruining a company and numerous lives through mere submission of allegations. It could be argued that the mere submission of allegations without thorough investigation created more victims, as the price of My Bitcoin had a high price of over $500 in 2017 and had now fallen to zero. With the CFTC case in trouble after Gomersall's admissions of faulty investigation and sole reliance of being presented the case by FINRA, the CFTC did what they always do when in trouble: call out the big guns. So, on February 26, 2019, the U.S. Attorney's Office in Massachusetts indicted Crater on 4 counts of wire fraud and 3 counts of unlawful monetary transactions. The case was submitted to the AUSA Jordi Delano in Massachusetts, but the real case was being prosecuted in the D.C. office by Caitlin R. Cottingham, a trial attorney in the fraud section of the criminal division. This case is a perfect example of collusion of multiple federal agencies, not in the pursuit of truth, but to lay claim in a new asset class by picking on low-hanging fruit. Support of that is the fact that Roche and Gillespie are named as individuals 1 and 2 in the indictment, but not indicted themselves. It is the DOJ's model to apply pressure to individuals as unindicted co-conspirators to cooperate and testify against any leftover defendants. This model is partially why, according to the latest statistics provided by the U.S. Sentencing Commission, that 97.4% of all federal defendants plead guilty. The statement from the DOJ. Let's begin the breakdown of the statement from the Department of Justice, DOJ, made in the case against Crater, directly from the DOJ website, linked at sherloc.substack.com. Quote, according to court documents and evidence presented at trial, Randall Crater, 51, of East Hampton, New York, founded MyBigCoinPay Inc., MyBigCoin. Quote, a purported cryptocurrency and virtual payment services company headquartered in Las Vegas, Nevada, and offered virtual payment services through a fraudulent digital currency, quote-unquote, MyBigCoins, which he marketed to investors between 2014 and 2017, using misrepresentations about the nature and value of coins, unquote. Quote, Crater and his associates falsely claimed that Coins was a fully functioning cryptocurrency backed by $300 million in gold, oil, and other valuable assets. Crater also falsely told investors that MyBigCoin had a partnership with MasterCard and that coins could readily be exchanged for government-backed paper currency or other virtual currencies. Crater promulgated these misrepresentations through social media, the internet, email, and text messages, unquote. In reality, coins were not backed by gold or other valuable assets, did not have a partnership with MasterCard, and were not readily transferable. Hard stop. We'll break down these points in more detail in part 2 of this expose, but it is critical at this point to clearly understand the foundation that the CFTC built their case on and who they relied on to build it. The curious case of Patricia Gomersall. Patricia Gomersall is a lead investigator for the CFTC with 31 years of experience. She submitted a declaration to the court under penalty of perjury in the case against Crater. That was the foundation of the CFTC's allegations and eventual prosecution in federal court. With documentation of the full Gomersall deposition, linked at sherloc.substack.com, and the sealed memorandum in support of certain defendants' motions for sanctions, also linked at the Substack site, were provided by whistleblowers. We can see that not only Gomersall's statements are in question, but that the CFTC and its attorneys prevented the court from making an informed decision and obtain relief in the form of what were crippling asset freezes against Crater and his family by blocking evidence. According to the filing, the CFTC, 1, alleged that the virtual currency in this case was not backed by gold. They failed to disclose evidence that it was. 2, alleged that a credit card tied to the virtual currency in this case did not exist. They failed to disclose their knowledge of a contract establishing such card. And 3, alleged that the reported trading prices of the virtual currency in this case were false and illusionary. They failed to disclose the evidence that the virtual currency's price was in fact determined by trading in the marketplace. The filing goes on to state that, quote, to be blunt, the CFTC's conduct during the ex parte proceedings and the effect of that conduct on the ensuing preliminary injunction is nothing short of attorney misconduct. It is a violation of the Massachusetts Code of Professional Responsibility, applicable to all attorneys who practice in the United States District Court for the District of Massachusetts. It is especially concerning because the attorneys who engaged in this misconduct represent an agency of the United States. In each motion for relief, the CFTC cited only one source of evidence: the declaration of Patricia Gomersall. Misrepresentations, prepaid MasterCard. The evidence of allegations from the CFTC are based on 2 alleged misrepresentations: that MyBigCoin had an agreement with TrueCash, aka DCR Strategies, to issue a branded prepaid MasterCard was false, and that the statement that the price of the MyBigCoin currency was determined by the market were false, neither of which appeared to be supported by evidence in the Gomersall declaration. In fact, the CFTC had evidence that directly contradicted their reliance on an unsigned letter stating that the contract for a branded MasterCard had been terminated. Gomersall admits this in her deposition under oath. Reading from a segment of her deposition, which is listed at sherloc.substack.com. Gomersall concluded that an unsigned letter purporting to be from the General Counsel for DCR Strategies to My Big Coin LLC, quote-unquote DCR letter, was a cancellation of a contract, although she took no steps to verify that the letter was authentic or that it had ever been sent or received. Question from counsel. So you took this at face value, and then you took the DCR letter at face value, and you believe that this document, the DCR letter, stating the credit card contract was canceled, to be more accurate than the press release, correct? Gomersall answer, correct. Question from counsel. All right, but you didn't call up anyone and ask. Answer from Gomersall, that is correct. Question from counsel. And in particular, you didn't call up Josephine Pereira Esquire, General Counsel for DCR Strategies, Inc. either, did you? Answer from Gomersall, I did not. Question from counsel. You didn't talk to anyone at DCR Strategies. Answer from Gomersall, I did not. Question from counsel. But you do know they had a contract with TrueCash, correct? Answer from Gomersall, I saw. Interrupted by CFTC counsel, Ms. Rodriguez. Objection, vague. Answer continued from Gomersall. I saw what appeared to be a contract with TrueCash. The signed contract with DCR Strategies and the full promotional material showing the MBC card and how it worked from TrueCash are both linked at sherloc.substack.com. This information, provided under oath, directly contradicts statements from the DOJ website mentioned above. Misrepresentations, alleged victims. The CFTC claimed that 28 MBC customers were impacted. According to Gomersall's deposition, the CFTC only took testimony from one customer. Reading from the deposition. Of the 28 MBC customers, the CFTC only took testimony of one customer, Customer A. Question from counsel. Says the transcript of sworn investigative testimony of My Bitcoin customer taken on July 19, 2017. Do you see that? Answer from Gomersall. I see that, yes. Question from counsel. Who is Customer A? Answer from Gomersall. Customer A is redacted. Question from counsel. And were there other customers whose testimony was taken? Answer from Gomersall. No. Because Ms. Gomersall had not spoken with any of the 28 MBC customers, quote unquote, she did not know whether they believed they were purchasing My Bitcoin currency from Mr. Crater or My Bitcoin Pay or My Bitcoin Inc. Question from counsel. But again, you didn't talk to any of these 28 customers, so you don't have any idea what they believed. Correct? Answer from Gomersall. I did not talk to any of the 28 customers. Correct. Question from counsel. So you don't know what any of them believed, correct? Answer from Gomersall. Correct. Despite using the phrase quote-unquote 28 MBC customers repeatedly, Ms. Gomersall did not know whether any of the quote-unquote 28 customers had actually bought coins from My Bitcoin LLC. Question from counsel. Which of the 28 customers do you believe that they were purchasing their My Bitcoin coins from My Bitcoin LLC? Answer from Gomersall. Yes, I don't know. Question from counsel. So I'm correct. You don't know whether not any of the 28 customers believed they were purchasing My Bitcoin coins from My Bitcoin LLC. Answer from Gomersall. Correct. Misrepresentations, lack of basic understanding. In a disturbing twist, Gomersall, as a CFTC expert and foundation for the CFTC's case, lacks a basic understanding of how virtual currencies work and did not take steps to support her allegation that Crater or his co-defendants arbitrarily changed the price of My Bitcoin currency. From the deposition, Ms. Gomersall took no steps to look at the quote-unquote MBC customers' wallets to see if they had received the My Bitcoin that was sold to them. Question from counsel. And is it accurate to say that you have not looked at each one of these 28 customers' wallets to see whether or not they got the virtual currency they had purchased in their wallet. Answer from Gomersall, that is correct. Note, Ms. Gomersall lacked a basic understanding of how virtual currencies are held and lacked an understanding of virtual currencies more generally. Question from counsel. Okay, do you have possession of the wallet numbers for the customers? Answer from Gomersall. I don't believe I do. Question from counsel. Do you know what a wallet number is? Answer from Gomersall. No. Question from counsel. Do you know what a wallet is in terms of, let me finish. Do you know what a wallet is as the term is used by the MyBigCoin website? Answer from Gomersall. Honestly, I don't know. Question from counsel. What does the term decentralized virtual currency refer to? Answer from Gomersall. It refers to a page in attachment 12 to the Gomersall Declaration. Question from counsel. So you don't know what that term actually means? Answer from Gomersall. No, I do not. Question from counsel. There's only two ways to really understand who the buyers and sellers are there not? There's the wallets that show whether the currency is in it and what the ID is on it, or there's the blockchain who can trace the transaction back. Answer from Gomersall. I am not an expert in cryptocurrencies, Mr. Fuller. I don't know. Note, Gomersall took no steps to investigate or corroborate the hearsay statement that she alleged demonstrated that the defendants arbitrarily changed the price of MyBigCoin currency by speaking or interviewing with customer C. Question from counsel. And of those 28 customers, did you even interview a single one of them? Answer from Gomersall. No, I did not. From this, it appears that the CFTC, a government agency that's positioned to lead the governance of the cryptocurrency industry, relies on faulty foundations in the pursuit of positive outcomes for them in bellwether cases. Misrepresentations. No investigation of MBC being backed by gold. In the statement from the DOJ, in part, says that misrepresentations, again, that's 3316. Misrepresentations. No investigation of MBC being backed by gold. The statement from the DOJ, in part, says that, quote, Crater and his associates falsely claimed that Coins was a fully functioning cryptocurrency backed by $300 million in gold, oil, and other valuable assets. Yet, during her deposition, Gomersall states that she, A, was aware of a commitment from Harmony International to back MyBigCoin Pay with gold, B, had no basis to believe that the MBC currency was not backed by gold, and C, did not investigate whether MBC currency was backed by gold. From the deposition, note, the CFTC was aware of a commitment letter from Harmony International to back MyBigCoin Pay with gold, and Ms. Gomersall did not investigate whether MyBigCoin currency was backed by gold. Answer from Gomersall. I recall seeing what was basically a cover letter. It did mention gold. It didn't seem to be in very much detail. That's why we sent a subpoena to Harmony to get more information. Question from counsel. But you made allegations that it wasn't backed by gold in the complaint. Did the CFTC not do that? Answer from Gomersall. Did the CFTC not do what? Question from counsel. Make allegations that MyBigCoin wasn't backed by gold. Answer from Gomersall. Yes. Question from counsel. And yet you didn't take any testimony from anyone associated with Harmony. Answer from Gomersall. Correct. That is correct. Question from counsel. You didn't take any testimony from Mr. Donahue, Harmony CEO and the author of the Harmony commitment letter. Answer from Gomersall. That is correct. Note from counsel. The above colloquy shows that Ms. Gomersall was aware of a commitment letter dated April 20th, 2015, from Harmony to MyBigCoin Pay, committing Harmony to irrevocably guarantee against any default by MyBigCoin Pay in a lump sum of up to $100 million in gold. Counsel note, Indeed, Ms. Gomersall admitted that she had no basis to believe that MBC currency was not backed by gold. Question from counsel. So you didn't have any factual basis to believe that my big coin wasn't backed by gold? Answer from Gomersall. Correct. In concluding part 1 of this expose, it's clear that might makes right, and the ends justify the means when it comes to the desire for power. We should also note that shortly after the jury verdict in the Crater case, the CFTC was front and center in a feature article linked here at sherloc.substack.com. That article reveals proposed bipartisan legislation from Congress to put the CFTC front and center in cryptocurrency legislation, increasing their support and funding. It also shows how misinformed, or aligned, or complicit members of Congress and some in the crypto industry are in their support of the CFTC having oversight of the industry, and that the foundations on which they propose and write legislation are based on and driven by false evidence, collusion, and conspiracy. In part 2 of our expose, we will show how John Roche controlled MyBitcoin, how Bill Donahue forged documents for the gold backing MyBitcoin and defrauded Crater in the process, video proof that MBC was real and functioning, and how the CFTC used this case to get funded. Do you have a case that's in need of research or an expose? Email us, asksherloc@protonmail.com. That's asksherloc@protonmail.com. All inquiries remain confidential. Thanks for listening to Sherlock Exposes.